the Court. For purposes of summary judgment, we've established that a public official, Mr. Marcy, planted evidence, namely shellfish, for the purpose of procuring the denial.
Have you established that?
For purposes of summary judgment,
The planting of shellfish?
Yes, for purposes of summary judgment, and I don't believe it's contested in this court, although it was in the lower courts.
The appeals court accepted that.
Correct. And I don't believe it's contested anymore.
Well, what about the collateral estoppel argument that, in fact, you litigated and lost that issue at the commission's at the hearing below?
Well, the collateral estoppel issue, Your Honor, fails on every prong of the collateral estoppel doctrine. The issue that they're referring to referred to the east side location, not the west side location. The west side location on the summary judgment record was a better place. It fails on all the other prongs as well, as we've argued in our reply brief.
So how does this action of planting the shellfish, is that what you're claiming is part of the violation of the civil rights statute, or is it simply the language in the conversations that preceded that?
It's both. It's the threats, well, the statements, three statements. Let me not characterize them for now. The three statements by Mr. Marcy, in conjunction with the planting of the shellfish, in conjunction with the report that Mr. Marcy submitted afterwards, and in conjunction with the natural effect of that planting, which was.
So it's not just the three statements.
No, that's right. It's more than the three statements, and we allege both.
This gives. It supports the idea that these three statements were threats.
It does, Your Honor. This all fits together, and that's
the
why
appeals court seemed to focus on just the threats and not the conduct, as if that was the limited thrust of the appeal.
I think it did, and it also focused mostly on just one of the threats rather than the other.
But were they wrong to focus on just the threats?
Yes, they were, and they were particularly wrong to focus on just one of the threats. Well, this is a quintessential jury question, and that's all we're arguing, to have a day in court on this issue. The three threats were, first, we'll do anything it takes. Mr. Marcy said, I'll do anything it takes to get this denied.
Excuse me, it's a jury question to decide whether a reasonable person would view these statements and actions as threats.
Correct, Your Honor.
That's it.
Just as a reasonable person standard under the tort principles would be a jury question. It is quintessentially for the jury to decide how a reasonable person would react in this circumstance. That's why we have 12 people decided. That's the whole reason why we have juries decide the question of what a reasonable person would do in the tort.
So it's a sort of Pheasant Ridge. You get to go to a jury.
Exactly. It's Pheasant Ridge and more, I would say. And Pheasant Ridge lays the groundwork for a third-party government agency, in that case the selectmen, to be sent to before a jury for making statements such as, we'll do what it takes to prevent this project from going forward.
Well, let's just take that statement alone. That statement alone surely wouldn't be sufficient to support this claim even on summary judgment.
Well, I disagree, although I don't have to. It surely would be sufficient, both because of Pheasant Ridge and because of the context, Your Honor. My client had various dealings with Mr. Marcy. He had received reports, so had the Conservation Commission from Mr. Marcy.
The fact that a public officer who's responsible for protecting shellfish takes the position that I'll do whatever I can to make sure you don't get a permit, you suggest means is a threat, intimidation, or coercion under the civil rights statute.
In this context, yes. Now, I mean, it may well be.
In this context, you mean in the context of him subsequently having planted shellfish, if that's what we assume?
And previously having submitted reports that we say were fictitious. He had done a number of things that Mr. Marcy had observed that were improper, that displayed a bias and an animus against this pier. And part of the reason that Mr. Kennie went to see Mr. Marcy on these three occasions was to confront him with the lack of evidence for the things that he was telling the Conservation Commission.
And what are the other two statements, by the way?
There was the other two statements are somewhat similar. The first statement had to do with the shellfish report by one Jacob Brunage, and Mr. Marcy and Mr. Kennie was talking to Mr. Marcy and said, look, the Brunage report shows that this is not shellfish habitat. And Marcy said effectively that I wish I'd been there, we could have done something about that. The third statement was
That's kind of innocuous.
Well, the third statement, not in connection with the facts in the third statement. The third statement was, again, Mr. Kennie was talking to Mr. Marcy and said, look, we've got low shellfish habitat. Why are you wasting your time going to do another report? And Mr. Marcy said, we can take care of that. Now, Mr. Kennie testified, and I've cited on page 21 of my brief, that he interpreted that as a statement that Mr. Marcy was going to alter the shellfish count, alter the habitat.
So let's assume that hadn't happened. Let's assume you've got just those three statements, and you're unable to establish, and there's no evidence that that Mr. Marcy took any further action to seed the shellfish area to affect the further test.
I think we would have threats, but we'd have a problem on the secured right prong of the argument. It wouldn't affect whether there were threats. It might affect whether there was coercion, because the implementation of those threats was coercive, and it had its intended effect. It resulted in the Kennies abandoning their west side application. If there had been no follow-through, there had been no planting of shellfish, I'm not sure how I could have shown that my clients' rights were deprived.
So let's assume at a trial that that is rejected by a jury, because presumably it's open to dispute.
It is open to dispute.
I mean, nobody saw this person do this.
Well, we had an eyewitness put him at the place doing things that are consistent with planting the shellfish, but he was not able to say, I saw him put shellfish in the water.
So if the jury rejects that prong, if you get to a jury, it rejects that prong, are the statements enough?
No, I have to prove deprivation.
Okay.
I can't win this case on threats alone. There's another element of the Civil Rights Act that I've got to meet.
But economic deprivation, correct?
Excuse me?
You got economic deprivation.
I do have economic deprivation, and on the secured rights test, that's not even, I think, a disputable question as to whether that constitutes a secured right. We do have a right to apply for the permit. I mean, again, Pheasant Ridge says that.
The appeals court doesn't cite Pheasant Ridge, do they?
Not until they responded to my motion for rehearing, or my request for rehearing. That's true. They did not cite that. We certainly cited it.
Didn't cite it, didn't discuss it, didn't do anything with it.
Do you
That's
think
correct.
Pheasant Ridge over, what was it, 99? What year was it decided?
It was about 20 years ago, almost
20 years,
before that.
okay.
1987.
87, between 87 and 2008. Do you think that that we have moved away from Pheasant Ridge? That it's a
Absolutely not.
stricter standard of what threats, intimidation, coercion mean?
Absolutely not, Your Honor. For one thing, I mean, this aspect of Pheasant Ridge deals with what a reasonable person could interpret a statement as being, and rules it's a jury question. So on that point, I don't think that there has been any case inconsistent with that. You do see other cases, and these are all very fact-intensive cases, to be sure, and that's part of the reason why we think this case belongs before a jury. But you have cases like Bell and Iazli, I think probably Hoffler as well, where there were statements made, and of course there were additional circumstances as well, statements made that we're going to do what it takes to prevent you from doing X, Y, or Z. And in each of those cases, X, Y, or Z had to do with developing the property, applying for a permit. I think that the holding of Pheasant Ridge has been reaffirmed on several occasions. It's certainly been applied on several occasions. And nobody has cited any suggestion, dictum or otherwise, by this court or the appeals court until this case, suggesting that Pheasant Ridge has in any way been.
What did they say about it when they turned down the petition for rehearing?
Well, they said that they certainly distinguished the selectmen from this situation.
Okay.
And, you know, I don't see the distinction. But in both cases, we're dealing with a third-party government agency or government official who is interfering with an application that's before a separate agency. They said that there are procedures established for getting a wetlands permit, but of course, so there are procedures also for a 40B permit and for taking property by eminent domain. So they try to distinguish it, but in our view, they're distinctions without a difference.
Do you agree with the statement in Mr. Keston's brief that you've not pursued any claim against the town DNR under the MCRA?
Well, we initially went against the DNR for injunctive relief, and also under the federal Constitution. The federal constitutional claim was amended out, and that's what his brief is about. When we finally got our permit, and that all happened after the Superior Court's decision, so that's not in the record. We finally got a permit that had conditions that my clients could live with. we recognized that injunctive relief was no longer appropriate. So we did not appeal as to the DNR. The DNR was dismissed under the State Civil Rights Act on the grounds that it's not a person. And we did not appeal that argument. We have taken up the question of whether we should have been allowed to reassert the federal claims, and that's, as I say, that's what Mr. Keston's brief is about.
Now, your clients took this as threats.
Yes.
And he carries a gun, doesn't he?
He does. He's a uniformed officer when he's in Dennis.
Well, you know, the appeals court just said that's unreasonable.
Right.
You
It is
say
not
that's for the
reasonable to
jury.
assume that Marcy was expressing an intent to inflict
You
physical
say
harm.
that's for the jury.
Correct. It's for the jury to decide what a reasonable person would have thought Mr. Marcy's statements meant.
What do you, the Superior Court judge said you hadn't, no secured right, correct?
Correct.
So I think the secured rights that you allege are the right to develop your property with due process, are not to be interfered with, the right to a untainted proceeding, which would be a statutory right, correct? Under
Both
13140?
Both statutory and constitutional, yes, Your Honor.
Well, the untainted part. The hearing is statutory. The untainted part is statutory and,
Well, I think they're both.
okay.
The statutory right to a hearing, we've cited other cases in
Okay.
other areas,
I'm
is a
with you.
statutory right to a meaningful hearing. And again, you can draw a parallel with Pheasant Ridge. In that case, the 40B application had already been filed. The court in Pheasant Ridge talks about the secured right being the right to file for a permit. I trust the court was referring to the right to file and get a meaningful resolution of that application. So the statutory right to file an application, the statutory right to get a hearing, is the right to have a meaningful process. And if an official, particularly outside the commission, interferes with that right by making that right meaningless, for instance, by planting evidence, we view that as a statutory violation as well as a constitutional violation.
The one that I'm having a little trouble with is the petitioning under Article 19.
Okay. Well, may I just back up to your previous
Yes.
question? Because I want to make one distinction clear, because I think that the Superior Court missed a distinction. Your Honor said the right to develop the property and the right to due process. Those are two separate rights as we view it. And in fact, the right to develop the property is a long line of decisions by this court, most recently the Hoffler versus Zotos, but it goes way back. It includes Pheasant Ridge. That is a right that doesn't depend upon showing that you had an entitlement to the permit. It's a right that, as I say, in Pheasant Ridge, the right was the right to apply. So those are two separate issues, and the Superior Court missed that, which is why I think we got off track and got into a due process analysis that was a separate question.
Well, except that you would not say it was a violation of the right to develop property if the town had properly denied the permit for the pier.
Yeah, if the shellfish count was as the study came.
Yeah.
No, the right to develop the property, as this court has articulated, it includes a right to apply for permits. The Pheasant Ridge was a right to apply case. There was no holding that the 40B permit was, that they were entitled to get it. There was a holding that it was bad faith to take the property. But that was a right to apply case. Iasley also involved a wetlands permit, similar to what we have here, not identical. It wasn't a permit to develop offshore waters. But the right to enjoy your property, the right to try to improve it, the right to file these applications is a right that is independent of whether or not there is a substantive entitlement to that permit. The fact that he's interfered with something that's discretionary, in our view, makes this much worse. If there were an entitlement, we'd have a judicial remedy. Because he has tainted a process that's discretionary, that may be it. I mean, we may have gotten the
No,
permit.
that's why I agree. That's why I guess I'm seeing those two going together. But
Well,
maybe it doesn't matter.
We've briefed them separately. I think they are separately. I would like to respond to your right to petition question, Your Honor. We have found the right to petition in a number of provisions of the state constitution. The Superior Court appears to have read the one provision of the Constitution as excluding other rights. In other words, it's only a right to apply to the legislature. Now, that makes no sense, certainly structurally, in terms of our Constitution and what our Constitution is about. Our Constitution has a right of free speech. Our Constitution has a right to pursue justice freely. It has a number of rights that are inconsistent with the notion that applying to the government is something that is completely at the discretion and whim of government officials and may be interfered with willy-nilly. Certainly the federal government, which has the same history on this issue, the same, I mean, these rights go back to the beginning of the Commonwealth and subsequently the beginning of the country. The same history, we submit, leads to the same result.
Thank you, Mr.
Thank you, Your Honor.
Wilkins. Mr. Davis?
Good morning. May it please the Court. My name is John Davis. I represent the defendant, Alan Marcy. And I would like to just follow up on a couple of questions posed by the bench to my brother with respect to the planting of the shellfish. That is very vehemently contested by my client. The allegations in the first amended complaint are that
I understand that, but why, if in fact the plaintiffs are able to establish that fact, it seems to me that that should be established by a jury, and doesn't that make their case?
No, Your Honor, because when they talk about the planting of shellfish, they need to establish that it was a deprivation or interference or attempted interference by threats, intimidation, or coercion.
Well, you got to accept the planting is true, don't you? Because this is, you got to accept that assertion is true, because this is summary judgment, isn't it?
I'm not contesting that there is a disputed issue of material fact with respect to the planting.
So for purposes of what we're doing today, we've got to accept that your guy planted the fish, quahogs, or whatever they were.
Understood.
Yeah. You're just correcting a little statement, but
In
that's
order
still...
to defeat the plaintiff's attempt to go forward with his permit,
Yes.
don't we have to accept that as well?
I don't know. I guess you would have to, Your Honor, at least with respect to disputed issues. I think in order to establish a right of recovery under this statute, and I think the problem is that this statute doesn't fit the plaintiff's claims. In order to recover under the Mass Civil Rights Act, they must show that it was the interference or attempted interference was by threats, intimidation, or coercion. If Mr. Marcy snuck in the dead of night and stuck shellfish in the waters of Bass River in such a way as to taint the DMF survey, that would constitute acts or some sort of a conduct which this Court, even in Pheasant Ridge and in Longball and in Senna, has said that the acts themselves, that's not threats, intimidation, or
Oh, I
coercion.
know it, but
Yes, but
he's
he's
making it plain that these things have to be studied in the context of these statements that were made. One of which is
I agree.
almost identical to what was said in Pheasant Ridge.
Right. So he would be suggesting that not only did he threaten, but he carried out his threat.
Yes.
And I think that's what he's trying to suggest.
Yes.
So I think, but the point is, I think you have to go back and look at the statements that were made in the context of the undisputed material facts that were before the judge at the Superior Court. We had 3 statements. We have the 3 statements that are, first of all, in November 15 of 2001, when Mr. Kennie confronts Mr. Marcy in his office to question the evidence of shellfish densities in Bass River. Mr. Marcy says words to the effect, allegedly, that I'm mandated to do whatever it takes to keep docks out of that area. And in the appeals court...
That I agree with you tends, at least to me, tends not to be a threat.
4 days later,
and did he-
Mr.
That strikes me as something to the effect, I'm going to do everything I can to stop this, or words to that effect. Was there such a statement?
I just described
he-
that one. That's the November 15, 2001, when he says, I'm mandated to do whatever it takes to keep docks out of this area. And as
And by what is he mandated?
Yeah.
as the appeals court mentioned, Your Honor, he is the shellfish constable, and it is up to him, and this is in the petition for rehearing, Your Honor, it is up to him to refute the evidence that the applicant is making that this is not a viable shellfish habitat. So he says in the
But
context...
isn't that a statement that could be objectively viewed by a reasonable person as a threat?
No, I don't think so, Your Honor, because I think you have to look at it in the entire
Well,
context.
everything I can. I mean, what does everything I can mean?
Well, I think a threat means that you have intentionally exerted some force to put someone in fear or apprehension of injury or harm. And I think that means that you have to look at the entire context of that statement and the subsequent statement and the statement thereafter, where Mr. Kennie goes in. These all take place in the office of Mr. Marcy, not on the site, not out on the property. Mr. Kennie goes in and he is confronting, and by his own testimony, he's confronting, he's aggressive. He says at one point he's trying to put the screws to Marcy to pressure him to admit something that Marcy doesn't agree to.
So you go to a jury, and that's what the jury finds, but don't you?
But I think, Your Honor, I think what I'm suggesting is when you compare what the minimal evidence that was before Justice Kane at the Superior Court, when you compare that to the evidence that this Court has considered in the Bell case and in the Hoffler case and in the Appeals Court considered in the Isley case, where you had intrusion, you had people, epithets being expressed, you had hostile, belligerent language over the course of time, repeated. I think, I agree with my brother, these are somewhat fact-intensive when you look at the particular cases.
But in this case, though, if those statements are viewed in the context of the planting, of the alleged planting of the shellfish, it appears as though the statements can be construed to mean that you, Mr. Applicant, are not going to be playing on a level playing field.
And I don't think, Your Honor, with all due respect, that puts, that rises to the level of a threat, that it puts Mr. Kennie in fear of injury or harm.
Mr. Davis, do you understand that part of the problem here is the language of Pheasant's Ridge, right? So I'm reading from Pheasant's Ridge because that was a summary judgment on page 781.
Certainly, Your Honor.
To 782, where the court deals with this. And it says, having summarized the language, these words do not threaten a person with arrest or physical eviction, nor are they unquestionably words threatening physical harm. We think the question whether the selectman or any one of them engaged in conduct prohibited by 11I cannot be resolved on a motion for summary judgment because there's a dispute. If the trier of fact concludes that the selectman's words, in your case Marcy's words, could reasonably be understood only to express an intention to use lawful means to block the development, those words would not be a threat, intimidation, or coercion. But implicit in that is that a jury could decide otherwise. I mean, that's what's worrying me in this case. It's the language of Pheasant's Ridge, not the other cases.
I understand that reading, Your Honor. And Pheasant Ridge was decided in 1987.
By a very distinguished judge.
I'm sorry?
By a very distinguished judge.
Who was the judge?
Mr. Wilkins's father.
7 years later, Your Honor, it was this court in Planned Parenthood when this court articulated the reasonable person standard. So the reasonable person standard had not yet been adopted at the time of the Pheasant Ridge case. And I think that that's important because that's what the appeals court did here. Looked at what limited information with respect to threats, intimidation, or coercion that was before the Superior Court and said that is not the stuff of Bell. It's not the stuff of Houfler versus Jones. It's not the stuff of Isley. We have to weigh it at some measure, and they simply said it doesn't weigh up. And I think that sort of a test was not used. It certainly had not yet been articulated at the time of the Pheasant Ridge case.
So you would agree with what was really implicit in Justice Botsman's statement that since 1987 we've sort of cut back on Pheasant Ridge?
I think you have.
Okay.
And I think also with respect to Pheasant Ridge, I mean, I think it's distinguishable as well with respect to the secured right, because even though that was a property interest, and we're talking about the use and development of property, there was a physical taking. That was the taking of the property, and in such a way that it took all the sticks in the bundle. Here, we're not talking about an invasion. We're not talking about trespass. We're not talking about someone's access that has been blocked or somehow impeded. What we're talking about is the plaintiff's claim that they are entitled to a permit to build a private dock into the public waters of Bass River. And I think
certainly they have a right to apply for a permit.
Yes.
And if in fact your client had threatened Mr. Kenny, with physical violence, unless he withdrew the permit, that would be
I would
a
agree, Your
violation. So his claim is that he withdrew the permit because of the intimidating acts and coercive acts of your client, including the statements made, which he viewed in the context of his prior knowledge of him, and then also reviewed when it appeared that he had planted shellfish to basically illegally or improperly defeat his claim. Why isn't that enough?
The facts before the Superior Court, Your Honor, are that he had already applied for his permit, and in the public hearing process, he changed the location of the proposed dock 6 or 7 times. I think there were 7 proposed locations for this particular dock.
So he didn't withdraw his permit?
No, he did not, Your Honor.
He just changed the location?
He changed the location.
But isn't his argument is they changed the location because of these threats, intimidation, and coercion?
I
They could
agree, Your
never
Honor.
go
That
forward?
that is the plaintiff's allegation. With respect to the secured right, when you're talking about an application under the Wetlands Protection Act, our position is that the plaintiffs don't have a secured right here, because this is Commonwealth tidelands. This is the plaintiffs do not have a right to build a private dock into the public waters.
They
And
have
as
a
these,
right to apply.
I'm sorry?
They have a right to apply.
Yes, we agree.
And I think the argument is that they have a right, they have a pretty strong likelihood of succeeding with a lot of conditions, right? Isn't that what they say?
Actually, Your Honor, the presumptions are that this would be a shellfish habitat, and there are a lot of hoops and hurdles that they would have to get through. So I think the presumptions work against the plaintiffs based upon the Wetlands Protection and the Riverfront Act.
But if they have a right to apply, doesn't that imply
them to a
within it
fair-
a right to be treated fairly?
Yes,
To
Your
have that
Honor.
application treated fairly?
Yes, yes.
So wouldn't that be a statutory right?
Well, I think what we're talking about is either procedural due process, and I think they had due process here, or some sort of a substantive due process, but I think the underlying thing is you have to have the protected interest, and our position is that without, when you're talking about building something in the public waters, they don't have a protected
So you
interest.
think Judge Kane's analysis was absolutely right on the money?
Well, I think that was one of our grounds, Your Honor. I think Judge Kane was correct. And then when it went to the appeals court affirmed the decision, albeit for different reasons, and did not address Judge Kane's analysis. And if I may, Your Honor, with respect to the right to petition, Article 19 does say it protects the right of the people to petition the legislative branch, to the legislative body, to redress grievances or wrongs. And here, the legislative body of a town is the town meeting. I know that the plaintiffs would like to suggest that it ought to be interpreted broader than that, but it specifically states in Article 19 that it's legislative body.
But the whole anti-SLAPP statute is premised upon a much broader right of petition.
Absolutely, Your Honor, it is, and it says right in the anti-SLAPP statute. It defines the petitioning right as something protected by both the Massachusetts Constitution and the United States Constitution, which is broader with respect to the right to petition, and it also enforces free expression and free speech. So it's not just Article 19, which is what the plaintiffs are relying upon here. Thank you.
Thank you, Mr. Davis. Mr. Keston?
Good morning. I'm here on something that's been talked about. This is the plaintiff's forum shopping in this case. As is not uncommon in the practice, the plaintiffs filed both state and federal claims in the state court. The defendants exercised their right to remove the claim to federal court. Immediately thereafter, the plaintiffs and the counsel decided they did not wish to litigate the case in the federal court and dismissed the federal claims.
Maybe they think they'll get a better hearing here, or maybe they don't want to have...
So what's the significance of that? Nothing.
No, I'm here because they then 9 months later changed their mind.
Oh.
The only reason I'm here is there is an appeal out there. You haven't talked about this, but 9 months later, successor counsel decided he wanted to troop back to reassert the federal claims and troop back to the federal court. And
Judge Donovan said too late.
Judge Donovan said you can't do that. You can't making these people go back and forth. So that's the only reason I'm here. It's a brief argument, but there's a suggestion in their brief. There's not an argument. It's an abuse of discretion for Judge Donovan to say you can't do that. You can't go back and forth. We've never seen it before. I haven't seen this attempt before. It is common, what happens here is common. The plaintiffs decide they'd rather be in the state court and go back, and that's the only reason we're here.
Thank you, Mr. Keston. We'll
Thank
take
you.
a short break.